Hello, everyone, and welcome to Legal Essentials by Exponent Philanthropy. Exponent Philanthropy is the country's largest association of funders and the only one dedicated to serving foundations with few or no staff, philanthropic families, and individual donors. Our vibrant network has in common lean operations and a style of philanthropy motivated by personal passion, community needs, and a strong desire for better outcomes. We provide high quality and cost-effective programs, resources, and connections that maximize our members' dollars and time for the benefit of diverse communities and causes. So today you're joining for the final module of the three-part Legal Essentials virtual seminar. By the end of this session, you should be able to recognize self-dealing and conflicts of interest. I'm Althea Georgantis, Program Manager at Exponent Philanthropy. I'm here in our DC office with my colleague Madeline, who'll be helping out with your questions today. You'll also see Lauren in the chat. We are recording this webinar. We also recorded the previous two. All of them will be made available to you after the program. You'll also get a copy of these slides. Like in the past sessions, if you would like to see the slides now, you've already been sent a link to the slides in the same email that had the link that you clicked to join today. Also, Madeline has sent in the chat a link to the slides as well as the previous recordings. And I know a lot of you have joined for the previous two sessions, but we do have some new folks. So I just want to give a quick overview of how to use Zoom. Your controls will be kind of here in the top left or down in the lower middle, depending on the version you have. Audio settings is where you can decide to call in by phone if your internet is shaky. And then most importantly is that chat function. That's how we'll receive all participant comments and questions today. If you'd like everyone to see your chat, if you just want to contribute to the conversation, you just have to enable the option to send to panelists and attendees. It's circled here in red before you click send, and that way everyone can see what you're saying. We will be pausing periodically to answer questions, so enter in your question as we go along and we'll do our best to get to it. I do want to mention that for this session, we will receive a lot of questions. We'll do our best to answer as many as possible, but we won't be able to give specific legal advice to everyone who's on the call. So, just be thoughtful about the questions you'd like to ask. And now I want to introduce you to our speaker today, Andras Kosaris. Andras represents domestic and international tax-exempt organizations on a broad range of regulatory, transactional, and operational matters. He also represents individuals and corporate donors on charitable giving. He advises exempt organizations on executive compensation, private foundation rules, unrelated business income tax, mergers, joint ventures, and the establishment of for-profit subsidiaries, as well as managing investments and endowments, including mission and program-related investments. He advises exempt organizations involved in tax and governance controversies, including internal investigations, disputes over charitable gifts and gift restrictions, internal investigations, and examinations by the IRS and state charity regulators. And with that, I'll pass it over to Andras. You probably recognize him from 2 days ago. And Andras, welcome.
Thank you, Althea. Just give me a thumbs up that you can hear me. That everybody can hear me?
We can hear you.
Perfect, thanks. So, well, welcome everyone, and it's great to see lots of folks joining from all over the country. I am based in Washington, D.C. So today's agenda is going to cover self-dealing, and then for the second portion, sort of a smaller segment on conflicts of interest. And just to provide the context, self-dealing is primarily the federal rule, right? The IRS private foundation self-dealing rules. Conflict of interest is a more broader concept that is fundamentally based in state law. So if you're a nonprofit, if you're organized as a nonprofit corporation, your state nonprofit corporation statute will apply. Or if you're organized as a charitable trust, the state trust rules will apply in how conflict of interest is identified and also managed and resolved. So conflict of interest is a broader concept, and I like to think of self-dealing as a subset of conflict of interest under the IRS rules. So self-dealing, but before I get to this slide, before I talk about this, I wanted to know that the IRS tracks data on penalties assessed for the various violations of the various private foundation rules. So the rule on self-dealing, the rule on the minimum distribution requirement, the payout rule, investments, expenditures and distributions and grants, all the various rules to which a penalty tax may apply. The IRS tracks data as to how much money, how much penalties are assessed for these various violations and rules. And it is interesting to note that, or I found it interesting, that the most the rule that is assessed the most in terms of dollar amounts is for the failure to meet the 5% payout requirement. And I found that somewhat interesting, given that the payout requirement is a fairly simple rule. So it's rather difficult, or in some ways, if you will, rather easy to violate. Whereas, for example, the self-dealing rule is a much more complicated and fact-specific rule. So I found it very curious as to why that is, why the difference is. And one thought is, of course, that the payout, the failure to meet the 5% payout distribution is something that is obvious and is reported on the Form 990-PF itself, right? You run your numbers, and it tells you whether you actually met the required minimum distribution. Whereas for self-dealing, even though the 990-PF does ask whether you have violated or engaged in a self-dealing transaction, it's basically self-reporting. So if, let's say, it's an inadvertent violation and you didn't happen to know that you violated the rule, you can't report that you violated the rule. So that's something that I found interesting. So the definition of self-dealing is it's a direct or indirect transaction, and usually a financial transaction, but not always, between the foundation and a disqualified person. And again, the foundation here is a private foundation. These rules do not specifically apply to public charities. The public charities have a more favorable and friendly rule that is somewhat similar, but it's more flexible. So how do you identify self-dealing? And I've always thought that Exponent Philanthropy has done a great job in just coming up with a three-step process, just simple in concept. So you have to ask whether the transaction involves a disqualified person. That's the first. If there's no disqualified person, then the self-dealing rules do not apply. Then you have to determine whether the transaction is listed as one of the self-dealing transactions. There are about 6 of them or so, and again, if the transaction does not fall within one of those categories, then it's not a self-dealing issue. And then finally, you have to consider whether there's an exception that applies. And there are exceptions to these rules. The rules start out very broadly and almost tend to prohibit everything. And then there are exceptions being carved out. So first, let's identify the disqualified persons. So they are your officers, directors, trustees, and others with similar authority, foundation managers. They are the substantial contributors to the foundation, so typically the founder. It's useful to think through this particular definition and rule about substantial contributors, because if anyone else next generation down the road, or even outsiders, independent third parties, happen to make a contribution to a foundation, you want to be careful whether they may end up being a disqualified person as a result. Then family members, spouses, descendants, ancestors, and their spouses. Notably not siblings. Siblings are not considered disqualified persons. So I think probably Congress thought when they were writing these rules back in 1969 that siblings keep each other sufficiently in check, and they usually don't let each other get away with anything. Certainly my siblings didn't let me. So we don't have to worry about including siblings within the definition. Then entities that that disqualified persons control, and then certain government officials, and we'll talk a little bit about government officials at the end. That's it. That's sort of the list. I often tell foundations that to the extent that it's feasible, have a little cheat sheet of your disqualified persons. So it's something that's readily at hand and you can figure it out easily. So a quick question. Is a niece or a nephew a disqualified person? So if it's simply as a result of family connection, then a niece or nephew would not be, right? Because they're through your siblings, and siblings and their family members are not disqualified persons. But if that niece or nephew becomes a trustee or a director or an officer of the foundation, or happens to have some sort of significant management role with the foundation, then that person could become a disqualified person. That's a good question. So a follow-up question to that, what if a niece or nephew is employed? So again, I think the question is there is a broader definition of, so it's officers, directors, and others with similar authority. So if you have, let's say, an executive director of a foundation who is an employee, but is not necessarily an officer, but has some signature authority over matters regarding the foundation, that person would be a disqualified person. If, let's say, a family member is or niece or nephew is an employee, but is maybe a program officer of the foundation, but would not have signature or authority or approval rights over various matters regarding the foundation's management and operations, that person is likely not a foundation manager under the definition of disqualified person and would therefore not be a disqualified person. I'm getting a few more questions that I'm just taking a moment to read. So a question about ex-spouses who were disqualified persons prior to divorce. Are they also, do they remain disqualified persons after a divorce? So the answer to that is if the spouse was a disqualified person because they were the spouse of a board member or an officer or a founder, then that after the divorce, that ex-spouse is no longer a disqualified person. Again, unless that ex-spouse fits within some of these other categories: officer, director, foundation manager, substantial contributor. I think that's where, for example, if a couple founded a foundation, then both parties would be considered substantial contributors generally. Again, depends on the circumstances, but generally. So even after a divorce, that ex-spouse could still continue to be a disqualified person. If you're a disqualified person as a result of your role of a substantial contributor, it takes a bit of effort and satisfying certain specific rules and requirements to stop being a substantial contributor. And that includes not having made any further contributions to the foundation and having no management or any role with the foundation for at least a period of 10 years. Previously, for a long time, it was impossible to terminate your role as a substantial contributor. You were always a substantial contributor if you became one. Now there's a way to terminate that process, but it requires satisfying some factors. So again, we talked about who are disqualified persons, and now, okay, let me take one more question. It's a good one. So if a grant manager has no decision authority over grants, right, but has the ability to vote for board members because she is a member of a corporate foundation, so of a membership type foundation, is she a disqualified person? So let's say you're set up as a membership style foundation where you have board members, but you also have members who vote and approve board members. And that's common. It's a very common structure to have control vested in a certain segment of, let's say, family members of the foundation, and to allow them to retain control. So in that case, that individual is, yes, in my view, would be a disqualified person because they have authority similar to a board member, and typically with those membership type structures, the members also have the ability to approve the dissolution or the amendment of articles of incorporation and bylaws and other significant transactions. So they would be considered disqualified persons. Well, I'll take one last question on disqualified persons. They're all great questions. So there's an accountant who is an executive director and trustee. The accounting firm does not do any work for the foundation, but again, the question is this person a disqualified person? Sorry, the accounting firm, is the accounting firm a disqualified person? So you go back and look at this definition, and this would be a matter of figuring out whether the accounting firm is an entity that's controlled by a disqualified person. So we know that the accountant is an executive director and trustee. So the accountant is a disqualified person. If the accounting firm, if the disqualified person controls more than 35% of the accounting firm, so as ownership or partnership interest, basically greater than 35% control over the accounting firm, then the accounting firm is also a disqualified person. So control in this context is basically you're looking for 35% or more control over this entity by the disqualified person. Okay, so let's move on to the types of self-dealing transactions. So these we'll go over in detail, but this is basically the list. So there are 6 of them, and I wanted to highlight 2 of them, which usually the ones that are the most significant and where most of the questions arise. And that's the 4th one, right? The payment, compensation, or reimbursement of a disqualified person. That's a big category. And then the one below it, transfer or use of income or assets of the foundation to a disqualified person. And I like to call this the catch-all category because it's very broad. It's the transfer or use of income or assets of the foundation to or for the benefit of a disqualified person. It's very broad, And we'll talk about this in more detail, but the questions that arise around tickets to fundraising galas, public recognition, naming rights, and other types of issues, those all fall within this catch-all category. So let's go through them one by one. So the first is the sale, exchange, or lease of property from a foundation to a disqualified person, right? This is prohibited, and this is your typically when you're leasing office space. And I think most everyone knows this rule, right? A disqualified person cannot lease office space to a foundation for charge. You can't charge rent to the foundation. But you can provide the space at no charge. One of the questions that comes up here is, well, can the foundation, so what happens if you want to allocate some of the utilities, phone, heating, other sorts of things related to the office space to the foundation? Can the foundation pay its fair share, its allocated share for those kinds of utilities and services? And the answer is yes. But if you do that, then the foundation should pay those charges directly to those third-party service providers. So the payment shouldn't go through the disqualified person and then the disqualified person makes the payment, but it needs to be allocated. So if you want to split the telephone charges and use, then the foundation would have to set that up directly with the phone company. And frankly, it's cumbersome, and that's usually the reason that most in these situations, the foundation usually and the disqualified person just don't bother, and everything is then just paid for by the disqualified person. Okay, so that's a fairly simple one. The next is the furnishing of goods or services to the foundation to a disqualified person, and this is back and forth, right? So this is the provision of services or goods by a disqualified person to the foundation, and then the opposite, the foundation providing goods or services to a disqualified person. So the first one, let's take the first one, the easier one first, which is if a disqualified person provides goods and services to the foundation, that can be done at no charge. If you look at the slide, it says at no charge and for charitable purpose. It's a curious addition, and I was actually looking at this more specifically recently. The regulations talk about, if the disqualified person wants to buy office supplies and pencils and stationery and other sorts of things, that can all be done. The disqualified person can provide all those sorts of things to the foundation at no charge. The regulations don't specifically talk about for charitable purpose. The statutory provision mentions that. I would say that the IRS probably reads that very broadly as to the basic operation, management, and carrying out the mission of the foundation. So again, the bottom line is the disqualified person can provide goods and services to the foundation at no charge. So then what about the opposite? Can the foundation offer goods and services to a disqualified person? And the answer is yes, under very limited circumstances, if those goods and services are offered to the general public and they are related to the foundation's charitable purpose. So what does this mean? So for example, if a foundation makes its conference space available to the general public to rent and use, then a disqualified person can also rent and use that space for on the same basis as is made available to the general public. So it's a very simple rule, and again, it's a very narrow exception. This usually doesn't come up. This sometimes comes up in the context of, if a foundation happens to have these large spaces, or maybe the foundation is engaging in some sort of research and wants to make data and other things available. If you make it available to the general public, you can make it available to the disqualified person. Let me pause for a couple of questions. So it's an interesting question. So one question is, can a disqualified person provide goods and services to a grantee of a foundation? And yes, so if a disqualified person wants to provide goods and services to a grantee, they can do that, and that would generally be an arrangement between the grantee and the foundation. And typically, if it's the grantee is usually going to be a public charity, and if the disqualified person wants to get paid for those goods and services, you just have to make sure that they're no more than market rates. Now, a variation of that question could be, well, can a foundation make a grant to a grantee on the condition that the grantee uses the services or purchases goods from a disqualified person? And the answer to that is no. So, let's say that and I'm just making up an example, but let's say that Microsoft had a Microsoft Foundation, and Microsoft Foundation makes a grant to a school on the condition that the part of the grant is used to purchase Microsoft products. Now, that would be a self-dealing issue. Another question is, can the foundation provide administrative support to trustees or to other non-employees who are not disqualified persons? So, that's an interesting question, and I think here, and this is an interesting point and a good point to highlight, that, so let's say you have non-disqualified persons, right? So we're not within the self-dealing rules. But the question raises the issue of, well, the foundation is providing administrative support to, let's make it up. Let's say family members, but who don't happen to be as disqualified persons, or others who are not disqualified persons. I think here, you might want to ask, well, is that something that is an appropriate use of the foundation? Is that somehow creating a private benefit to specific individuals? I would look at that rule. There's this private benefit rule overall that applies to all 501c3 organizations. And that is that as part of your operation and management of the organization, you're not supposed to provide private benefit to specific individuals or organizations. Now, another question is, and let me just also add a variation to this. So, let's change the facts and say, well, it's providing administrative support to disqualified persons, trustees, or other non-employees who are disqualified persons. Again, I think it's the same analysis of, well, if the foundation, if the foundation is providing certain support services to trustees in their role in carrying out their management of the foundation, yeah, you can provide that kind of administrative support. But if there is a disqualified person who does not have some sort of official role with the foundation, and the foundation is thinking of providing administrative services to that person, I think that would be a self-dealing issue, because the foundation would be providing goods and services to a disqualified person, not on the same basis as available to the general public. Another question: can a grantee C3 give promotional gifts to the grantor? Now that's a good question, and I'm going to defer that to my catch-all category. So it's basically this issue of, well, can the foundation accept gifts and other sorts of things from their grantees? And if it does, what can the foundation do with it? And more specifically, what can the foundation board members, officers, and other disqualified persons do with that stuff? You give a grant to the museum and you get tickets. You give a grant to the theater and you get tickets in return. What can you do with that? So let's just table that, but I will definitely come back to that. Now, another question is, and this is a good question to talk about, direct versus indirect self-dealing through grantees. So, we talked about the example of you cannot give a grant to a grantee on the condition that the grantee uses those funds to purchase goods and services from a disqualified person. But let's say that you give a grant to a grantee, and the grantee has sole discretion to pick and select a service provider for whatever they need for that project. And they end up picking a disqualified person. Now, that is permissible because it is not within the foundation's control as to how the grantee used those funds. It's purely within the grantee's control. Now, in certain situations, foundations do sometimes go the extra step of actually prohibiting the use of the grant to make payments to disqualified persons by the grantee. And the typical case that arises here is, let's say that a disqualified person, let's say the spouse of a board member, is the executive director of a grantee, right? In most cases, the foundation is going to say that, and the foundation provides a general support grant, or some other project grant. The foundation is typically going to say that the foundation's grant cannot be used to pay in part or whole the compensation of that disqualified person, of that spouse of that board member who's a disqualified person. And that's a useful rule to keep in mind, and a useful safeguard to implement when you know that specific relationship, because that does raise a self-dealing concern if you are not firewalling the grant money from, let's say, payment of compensation to the disqualified person. In the other example of just, you give a grant to a grantee, and the grantee uses to purchase things from the local hardware store, which happens to be owned by the family that founded the foundation. And the hardware store happens to be a disqualified person. again, it's not, as long as it's not within your control. I think you can be safe that you don't have to include a requirement that prohibits the grantee from buying things they need at the hardware store. All right, let me move on, but there are a lot of good questions coming in, so I will come back to that. But I just want to, and most of the questions that are coming on are falling within this catch-all category, so we'll definitely get to them. So the next one is this loans and extensions of credit to a disqualified person. And again, this goes both ways, right? So a disqualified person can provide loans to the foundation as long as there's no interest charged, and the proceeds of the loan are used for charitable purposes. It's not, for example, that the disqualified person is making a loan to the foundation so the foundation can make an investment play. It has to be for some charitable purpose. So that's, again, permitted as long as there's no charges or interest. And the other way, of course, is not permitted, right? The foundation cannot provide a loan to a disqualified person. So this usually comes up with credit cards. And I admit I'm not a fan of having foundation credit cards, but there's nothing wrong with them. I just think that they can be an administrative hassle, and they can lead to these pitfalls, including here. So the example is you take out your foundation credit card by mistake to purchase some personal item. Well, technically that's a self-dealing problem, because all of a sudden the foundation has just made a loan to a disqualified person that has nothing to do with the foundation's business. Now, typically you catch this and you'd undo it, and it's fine, but it's something to consider. And this applies to I would say this applies for credit cards. There's a question that just came in. Well, does this issue apply to debit cards? And the answer to that is yes, because if you take out the foundation's debit card, right, and you charge a personal purchase on that debit card, that's still the use of the foundation's money, and the foundation is basically loaning you money. So whether it's a credit card or a debit card, I don't think that that would matter here. Again, I think it's overall, again, having a foundation credit card is permissible if you have good policies, if you have good internal controls, and it works for you. I don't think you need to change anything. But if you keep having problems and if you keep making mistaken charges, it may be time to consider cutting up that foundation credit card. And then, of course, the flip side of that is, right, so while, if you don't have a foundation credit card, what are you supposed to use? Well, like with all of us, and, anyone that's usually, some sort of regular employer, you use your personal credit card, and then your company or employer, or in this case, the foundation, would reimburse you for that purchase. You're making purchases related to the foundation's business on your personal credit card, and you get reimbursed for that. And you just have to have a proper, reimbursement policy. You want to make sure that reimbursements are requested in a timely fashion, you get receipts, so on and so forth. You know, the usual processes for reimbursing expenses. Okay. So compensation. So this is our sort of first big category, right? The payment of compensation for personal services and reimbursement of expenses, right? We just talked about that. For personal services related to the foundation. And so this encompasses providing compensation, getting reimbursed for costs incurred. This includes, you know, paying board members, directors, or trustee fees, having the foundation buy directors and officers liability insurance that the foundation pays for. So the key here is personal services. You see that in quotes and italics. Because that's what's permitted. You can pay for, pay compensation and make reimbursements for personal services. Personal services is not defined. You would not be surprised that it's not defined. You know, why would the IRS bother to define something as simple as personal services? Well, so the regulations do give some hints. They specifically mention investment management services, accounting services, and of course, legal services as within the definition of personal services. You know, legal services, of course, are included because lawyers wrote the rules. So why wouldn't they carve out an exception for themselves? At least that's how I look at it. So again, investment management, accounting, banking services, and legal services. Then there are some case law and guidance from the IRS that seems to broadly talk about professional white-collar type of services as falling within the scope of personal services. You know, we don't exactly know where the lines are here. You know, some people read it somewhat expansively. Some people read it somewhat broadly. Some people think about, you know, the risks involved, how much money is at stake, what the service specifically is. So there's some factors to consider, but you know, there's definitely something to be said about thinking of professional services, white-collar types of services falling within the definition of personal services. If you have a specific question on this, I would say that you really do need to just talk to your legal counsel to see where those edges are specifically, because it makes a difference because there's a penalty associated with self-dealing, you know? So you do want to be somewhat careful here. So let me just, hold on a sec. I'm just trying to get to the chat window here. Now the other, and of course, another broad category of personal services is the foundation management services. So that's why, for example, that, you know, if you charge on your personal credit card travel expenses or registering for a conference related to, you know, an Exponent Philanthropy conference, why the foundation can reimburse you for those expenses, because those are related to the management and operation of the foundation. So, you know, if a trustee, a board members, officers go to some of these conferences for professional development, you know, those can all be reimbursed as long as they're reasonable to the, you know, they're reasonable in costs. Now, let's see, use of cars for, if the foundation has a car and the and the disqualified person uses to drive some personal errands, is that a self-dealing problem? And yes, I would say so. You know, any use of the foundation's assets for personal use that doesn't fit within this definition of personal services, it's not related to the management of the foundation, would be would raise a self-dealing concern. Another question is, can the foundation reimburse first-class travel? Noting that many airlines are just have sort of coach or first class, nothing much in between. Sometimes on these shorter flights, you don't really have business class. So yes, the answer is, as long as the rule is reasonable and necessary. So the compensation or the reimbursement has to be reasonable and necessary. And reasonable and necessary is basically pegged to market rates. Oftentimes foundations have and organizations have a policy of, you may fly business class or first class on flights that are longer than 5 hours, or if there's some sort of medical necessity that may be at play. On shorter domestic flights, and also international flights. On shorter domestic flights, I would say, in my experience at least, most foundations are going to not allow reimbursement for first-class travel. And it doesn't mean that under the rules specifically they would be prohibited. I would say that rule has evolved and practice has evolved over the years. About 10 years ago, there were a lot of investigative reports done on trustee fees and other expenses incurred by board members and officers of foundations, including first-class travel. And there were a lot of stories written. They're always interesting to read by the general public, and everybody is outraged that the foundation would pay for first-class travel. So I think it's more of a, I think currently I would categorize best practices as not paying for first-class travel, again, unless it's international travel or longer flights. But it's not legally prohibited. But if you do it, you are, you're definitely at a greater risk of somebody coming along and writing a story about you. So it's a PR issue oftentimes. A question: so how reasonable board fees are defined by the IRS? So reasonable board fees, as with everything for personal services, what is reasonable is what other foundations would pay other people for similar services. So it's basically comparability data. It's comparability data, and you can collect comparability data in a number of ways. You can go to GuideStar and pull a bunch of Form 990 PFs from other foundations and take a look at what they're paying their board members. You can look at published comparability data. Exponent Philanthropy collects comparability data and makes it available. The Council on Foundations has comparability data. Other regional grant-making organizations and infrastructure groups also collect their own comparability data. And they provide a range. You have to look at the factors. Are you a similar foundation? Are you doing the same kind of work? are we a foundation that gives two grants to a cultural grantee and then we're done, versus an organization that gives 30 smaller or larger grants and is heavily involved with their grantees. So you have to look at the work involved and make sure that what you're comparing are apples and apples. You're comparing similar types of foundations and similar work, not because the IRS, if you're under audit, that is exactly what the IRS is going to be looking at. If you're ever audited on compensation issues for board members, the IRS will want to look at your board minutes to understand how you approved it and what data you looked at to determine the fees and compensation involved. That is what they're going to be asking for. You want to be able to have a pretty good answer for them. And then for other types of services, right? Let's say it's investment management services, accounting services, banking services. Let's say you want to have one of your board members provide investment management services to the foundation. What are the fees charged? Well, what is the market rate fees for similar investment services? There's a question about compensation. So again, a couple of questions about just compensation overall. So you have to figure out if you're paying compensation to disqualified persons, what are you paying them for, right? So if it's board fees and trustee fees, if you're paying them for their role in the oversight of and governance of the foundation in their role as board members, that's fine. And then you can look at the comparability data as to what other foundations do in terms of how much they pay for those kinds of services. Then another category is if somebody is an officer or a program officer or employee or engages and provides some sort of foundation management services to the foundation. And it doesn't matter what role. You can be an employee, you can be a program officer. You don't have to be an executive director. A family member doesn't have to be an executive director. They can be a program officer. They can be a director. They can be, they can answer phones. They can do a number of different things as fits within the category of foundation management that for which they can be paid. So that's something to keep in mind. Now, of course, if they're not providing any services, then of course you wouldn't be able to provide them any compensation. They have to provide some sort of services to the foundation. Now, there's another question about, can a private foundation purchase liability insurance that is from a company that is owned by a board member's son? So just and the premium charge is within market rates. So let's just step by step, right? So do we have a disqualified person? Well, we have a board member and the board member's son. So board member is a disqualified person. The family member, right, son is a disqualified person. Now, what about the company? Well, if the company is at least 35% controlled by the board member's son, then the insurance company is a disqualified person. So the question becomes, is providing liability insurance a personal service? that would fall within this exception that allows the foundation to purchase this policy from this disqualified person, the company that's a disqualified person. And I'm going to punt on the answer to that. I will give my gut reaction, which I would say I think it is not a personal service, but I think that's something that you would want to look at, whether the providing liability insurance fits within the definition of personal services. It might, but my gut says no. But so here again, this is something that we're struggling with. I must say, on a weekly basis, I get questions trying to figure out what fits within the definition of personal services. I think that's a question that you would want to track down if that's a transaction you want to engage in. Another question about, well, how do you determine compensation if the disqualified person has multiple roles? And I think the answer to that is you can take all those roles that this person provides, an executive director, a program officer, etc., and come up with a reasonable amount that would be appropriate. You can't just tack on and say, wow, this person is doing everything, so let's just multiply the compensation by 3x, 4x. But this does come up, for example, with, let's say, a foundation, a family foundation that's staffed by all board members. Now, there's no separate executive directors. There's no separate program officers or program people. The board is doing everything. The board is approving the grants. The board is reviewing grant requests, doing site visits, managing everything. In that case, you want to separate, and you could take into account that, maybe the board members are getting board fees, but on top of that, they're doing all these additional work, so it would be appropriate to provide them a higher compensation. Now, a couple of there's a couple of follow-ups. As I was talking about that, there were a couple of follow-up questions on the this insurance question. So let's say that the company takes no commission on the provision of the insurance policy. So I think then you're back to this category of, let's see here. Oops, I'm going the wrong way. So there's back to this category of the disqualified person can provide goods and services to the foundation at no charge. I think if there's no fees, commissions, any payments whatsoever to the insurance company, then I would say you're in this exception to the self-dealing rules where the disqualified person is providing goods and services to the foundation at no charge, and you should fall within the exception, and that would be fine. A variation of that question is, well, let's say that it's not a board member but a trustee emeritus, right? So it's not, there's, let's say, no voting authority. Maybe if the person is on an advisory board, not active on the board, then that person is no longer a disqualified person because they're not exercising the role of a voting board member. So then all the nobody else related to that person would be a disqualified person as well. So then again, I think that just illustrating that looking at and asking a question, are we really talking about a disqualified person? So I think it's a good way to think that, you know, if the rules change, we have to reconsider whether we're dealing with disqualified persons anymore. Okay, so let's move on from the compensation, and let's talk about this catch-all category. And it's the transfer or use of income or assets of the foundation to a disqualified person. And so this is prohibited unless, and the exception here is, unless the benefits are incidental and tenuous. And of course, again, the IRS does not define what incidental and tenuous means. But we do know a couple of things. We do know that naming rights, public recognition, is an incidental and tenuous benefit. So you have a foundation and you give a grant and you want to put the founding person's name on the building. You can do that. You don't have to put the foundation's name on the building. You can put the individual's name on the building. So that's all fine. We do know that fulfilling a legally binding charitable pledge is not permitted. So we can't do that. We can fulfill, the foundation could fulfill a non-legally binding pledge. Whether a pledge is legally binding or not legally binding is a matter of state law, and it can be rather confusing. So my view on this tends to be on the conservative side. Again, as a rule of thumb, stay away from pledges. You know, if there's a pledge involved, just tread carefully and probably talk to your lawyers. And then our favorite category, tickets to fundraisers. So here, the issue is that if a foundation purchases tickets to a fundraiser of a grantee, and the grantee provides tickets, who can go? Well, the easy answer is that the foundation managers, board members, officers, you know, the foundation managers, employees of the foundation could go in their capacity as representing the foundation. Spouses, friends, or anyone that does not have a role with the foundation cannot and should not go and attend these fundraiser events on the foundation's dime. Now, again, my little rule of thumb is that if you're if you really do not want to go to a fundraising gala and your spouse really doesn't want to go to the fundraising gala, you're probably okay and you could probably go. But if you really want to go to the fundraising gala and you really want to take your spouse, then you really have to be careful about figuring out whether your spouse has some sort of management role with the foundation. And the point being is that there's flexibility here in terms of, we don't want to say that, well, you can't take your spouse under any circumstances, or you can't take your friends or someone who's unrelated to the foundation under any circumstances. Because there are situations, for example, where you're in a community and in order to show appropriate support to the grantee at their annual gala, you want as many people to show up as possible. And it may be appropriate to drag along your spouse and your friends or other potential individuals who might be in a position to make donations or provide some sort of support to that grantee. circumstances do matter. I think, we say as a rule of thumb, only the folks who have some sort of official role with the foundation should be going to these sorts of things. But circumstances matter, so it's worth taking a second look. Now, of course, if the board member pays for the ticket to the fundraising gala with their own personal funds, then you can take along anyone you want. What you cannot do is bifurcate. You cannot have the foundation, right? So bifurcation, what do I mean by that? We've all been to fundraising dinners, and typically the organization is going to tell you that, here's the, it's $100 per seat, and $75, let's say, is tax deductible. $25 is not. $25 is the cost of the event space and the rubber chicken that you'll be eating, and that's not deductible because that's the goods and services that you're getting back. Bifurcation means that in that case, the foundation would be paying the $75 for the tickets, and the board member would propose paying the $25, the non-deductible $25 from his or her own personal funds. That is bifurcation and is not permitted. Bifurcation doesn't solve this problem of bringing your spouses along. Now, so then let's talk about what if the charity, the grantee, provides tickets for free to the board and staff of the foundation. Now, yes, when you say for free, correct, but presumably the foundation received those tickets because the foundation's support of the grantee. So it's not entirely free, but the foundation didn't have to pay extra for it. So this comes back to my earlier question of what do you do with the stuff that grantees give to the foundation in return for a grant? And again, oftentimes it usually arises in grants to cultural institutions, the theaters, the art museum, the zoo, and you get tickets, you get access, you get other sorts of things. The best thing to do is to just say, no, we appreciate it. We cannot use it. Another option is, legally, the foundation board members can use it in their official capacity as a foundation. An alternative option is you could try to find some alternative use for those tickets that maybe is within charitable purposes. Maybe give it to a school or a group or something like that. But you do have to be careful with how you use these sorts of tickets. So, a question. So, can a foundation? So, the question is: so a foundation should not be a table sponsor for a nonprofit fundraiser and invite guests to fill the table. So again, that's a great question, and let's just back up. So we need to understand and make a distinction between the use of tickets for disqualified persons or for non-disqualified persons. So like a spouse would be a disqualified person, and we need to consider, well, is this spouse allowed to use the tickets? If the spouse is a disqualified person, does the spouse have any other official role or other role with the foundation that may merit using those tickets? If it's an invited guest that's not a disqualified person, then you don't have a self-dealing problem, right? Because you're not talking about disqualified persons anymore. And in those cases, you need to come back to this private benefit issue. are you inviting guests as a guest of the board member as a personal favor, right? Are you looking out for the personal interests of the board member in inviting these guests? Or are you looking out for the interests of the foundation and the interest of the grantee in inviting these guests? So that's where I would make the distinction, and that's how I would clarify. So let's move on, and maybe we can come back to a few more questions towards the end. So the last self-dealing issue is the payments of money or property to government officials. This is prohibited, and of course the helpful slide is basically you need to talk to your lawyers. This is a tricky one. There are some very narrow exceptions here. What happens typically is a foundation wants to host a conference or an event, and a government official is invited. And the question becomes, well, can the foundation reimburse the expenses, travel expenses of that government official, or maybe pay an honorarium to the government official? And usually the answer is yes. You just have to be careful. There's some sort of, rules are specific, so you just have to look at it. But typically, yes, you would be able to provide that. And then on top of the other thing to keep in mind with government officials is on top of the IRS private foundation rules, you have to be aware and make sure that the government official is complying with the government ethics rules, right? So maybe the self-dealing rules permit an honorarium or reimbursement of travel costs, but the government ethics rules that apply to that particular person may not. And, that's not necessarily your issue, but something to keep in the back of your mind. Slide to remind everybody that there are penalties involved. There are penalties on the self-dealer. There are penalties on the foundation managers, like the board members and others who approve a self-dealing transaction, knowing that it is self-dealing. The most difficult thing with the self-dealing rules is not just the penalties that apply here, but you have to undo the transaction. So it's not just, okay, well, we'll just pay a 10% penalty. You have to undo the transaction. If you've ended up paying excessive compensation, you have to undo it. If you've made certain payments you shouldn't to a disqualified person, you have to undo it. All right, so conflicts of interest. We'll spend the last 15 minutes or so on conflicts of interest. Yes, hold on, let me just back up. This question came up. 10% on what? It's 10%. The penalty is 10% on the transaction that is self-dealing. So if it's, let's say, take the example of compensation. So let's say that you pay board members $100,000 in board fees, and based on market rate and comparability data, only $20,000 is reasonable. So you have an excess of $80,000. The 10% penalty is assessed on the $80,000. Another example, if let's say a disqualified person happens to charge rent for office space to the foundation, then the entire rent is subject to the 10% penalty. So again, conflict of interest, I talked a little bit about the beginning. Conflict of interest is a matter of state law, and I divide conflict of interest into two categories: financial conflict of interest, and self-dealing rules are a subset of financial conflict of interest, and non-financial conflicts of interest. So both are covered. So, these are some examples. So a foundation board member serving on the grantee's board, that in my mind is a non-financial conflict of interest. You're not necessarily paying any financial benefits to the board member, but there is a non-financial related arrangement or relationship. board member's nephew serves as an executive director of a grantee. That could involve a non-financial, but it could also involve a financial conflict of interest. Spouse, spouse of a board member is a brother, and in here we'll come back to this, but that's a trick question, and of course, remember there's a brother there. It turns on definition of a disqualified persons. I think, as you all know, and I think all foundations should have a written conflict of interest policy that lays out, doesn't have to be overly complicated, but that talks about how do you manage and resolve conflicts of interest, both financial conflict of interest and non-financial conflict of interest, if that's something that you want to address. And there are a couple of steps. It basically requires disclosure, including an annual disclosure of any potential conflicts, and the disclosure is, not just on an annual basis, but as conflicts arise. So if you happen to be sitting in a board meeting and something comes up, oops, that sounds like a problem for this particular board member. That board member needs to raise their hands and say, well, I may have a conflict of interest here. So transparency and disclosure is important. And then how do you resolve it? Well, so the conflicted person can share information about the arrangement, why this is a conflict. But then the conflicted person should be recused from any final discussion and should be recused from any vote in the matter. And your board minutes, if we're talking about a board member here, the board minutes should reflect that recusal from the discussion and from the voting. Most states, again, this conflict of interest generally is governed under state law. You do want to look at your specific state law, whether there are any requirements that apply to you specifically. New York, if you're a New York nonprofit corporation, the New York Nonprofit Corporation Statute requires all nonprofit organizations to have a written conflict of interest policy with specific provisions in the policy. So you'd want to take a look at that. So what are the penalties for mismanaging conflict of interest and violating the state rules with respect to conflict of interest? So as opposed to monetary penalties for self-dealing transactions, conflict of interest penalties are basically a reputational risk, right? Journalists love writing about conflict of interest because people tend to think that it's something shady is going on. If you're hiring a board member to manage your investments, there's got to be something going on, right? Why can't you find an independent investment advisor? Why do you have to find somebody that's, board member? So people tend to think that there's something shady going on. So you just have to be careful with it and how you manage it. It can also trigger a review by the state attorney general. The state attorney general is the person in charge of regulating and supervising charitable organizations, including private foundations. So if the state attorney general happens to wake up one morning and read a story about you in the New York Times or the papers, that state attorney general is going to come and ask some questions, as is going on with one such private foundation in New York. And there are probably others under review as well. So the AG it can be pretty active here. And the one thing to keep in mind with the Attorney General's authority is that the Attorney General can literally pick up the phone or send you a letter the day of reading these articles or stories or getting some information about something that's going on. In contrast, the IRS, while they do read the newspapers and they can trigger an audit, they can trigger an audit only based on information you provide in your tax return. So let's say that something is happening this year, they would have to wait until you file your tax return for this year before they could actually open an audit on this tax year. And the state attorney general has much broader remedies than available to the IRS. Again, the IRS is just a monetary penalty. And if it's egregious self-dealing, then they have the authority to terminate and dissolve the foundation. But the state attorney general, for example, has the authority to remove board members in addition to shutting down a foundation and asking for restitution. The state attorney general also often makes referrals to the IRS for follow-up audits. Okay, some tricky situations. So this is, we're sort of winding down and just thinking through, again, how do you analyze, how do you think about this stuff? And again, it's easy to come back to the the basics. So you ask, is it a self-dealing issue? So you go through your self-dealing definition, your 3 questions. If it's is there a disqualified person involved? Does it involve a self-dealing transaction? Is there an exception? And if there's no exception, if it's a self-dealing transaction and there's no exceptions, then you can't do it. Okay. If you're able to come up with an exception, let's say it's, again, back to my investment advisor example, then you trigger your conflict of interest policy and you follow through on that. So you're sitting in a board meeting and the question is, well, we would like to hire one of our board members to manage the foundation's assets. So you go through the self-dealing analysis and you conclude that, okay, the board member could manage the foundation's assets because investment management services is a personal services, so it fits within the one of the exceptions to the self-dealing transaction. But now, what do we need to do to get this person approved to do this work? Well, you want to again, disclose, obviously, and then have a discussion and approve the arrangement without the person in the room and without the conflicted board member approving the transaction. And on top of that, of course, the arrangement has to be market rate, so you want to be able to document that you have looked at market rates. So these are a couple of these hypotypical situations. So this is, we have a foundation director and a daughter. The daughter of the foundation director or the sister of the foundation director is an employee of a grantee. So what do we have here? And this is meant to make a distinction between, again, the definition of a disqualified person. The sister wouldn't be a disqualified person, but the daughter would be a disqualified person. So again, in one situation you have a self-dealing issue, the other you don't. And then the second one is same thing, legal versus landscaping services provided to the foundation. Legal services fits within the definition of personal services, but landscaping services do not fit within the definition of personal services. So I'm going to leave this slide up just to compare, give you a sense, again, compare as to what the difference between self-dealing and conflict of interest. And then as let me scroll back through and see if there are any questions. We have about 5 minutes left. see if there are any questions that I haven't answered. There's a question about government official or government employee. Can a government official or employee be on the board and be paid as a board member? I believe the answer to that is yes, because they would be providing foundation management services. You'd want to double check that again, but I believe the answer to that is yes. But again, you want to make sure that that person has just confirmed and checked with their own internal government ethics rules that not just serving on the board in that capacity is permitted, but getting paid is also permitted. So you want to check for both. Let's see here. I think some of these other questions were related to, hopefully we covered these questions about grantees providing these various sort of things to the foundation. Again, I view that as this catch-all category, and you want to be careful about who uses the things. Promotional gifts, hats, T-shirts. To the grantee provides promotional gifts to the foundation. Who can use it? Who can wear it? And I think it's some of this, frankly, is a bit of a judgment call. Let's say it's a grantee that gives promotional gifts to the foundation, and I would say that in most circumstances, absolutely you will want to have folks wear that and use it as much as possible. You're promoting your grantee. So look, in that situation, the board member doesn't want to wear the T-shirt, but the spouse wants to wear the T-shirt, or the kids want to wear the T-shirt. I say go for it. Maybe think through the rules again, but sounds like something that would be permissible. And you're walking around and somebody's promoting the grantee. I think that's a good thing to do, and I think the rules would probably allow you to do that. Let's see here. Now, there's a question about what if a family member of a trustee, for example, has received services from a school, hospital, or other grantee agency? Does this give rise to a self-dealing issue? So this is a good question, and it comes back to this exception of if the foundation, if the grantee is providing those kinds of services to the general public, and the individual, the disqualified person, is receiving the same services as available to the general public, then this wouldn't be a self-dealing issue, and it wouldn't be a conflict of interest issue. You are the same class. You make a huge gift to a hospital. Yes, all disqualified persons can be treated at that hospital. If you're getting certain specific additional benefits that are not available to the general public, then that can trigger a self-dealing concern. Another question is, can a family foundation's disqualified person who is a board member and a caterer cater a board dinner? And that is, so the question is figuring out whether the catering company catering a board meeting, board dinner, fits within the personal services exception. And I'm not going to answer that. I think there are arguments on both ways. I think there are arguments that it fits within the personal services exception. I think there are probably arguments that it may not. And I think it's a good question. That I think it's a tricky question. Another question back to this issue about the providing hospitals and schools, etc. What happens what happens if if you find a hospital finds out who this person is and they're trying to provide special treatment or VIP treatment or things like that. But I mean, I think again, it's a bit of a judgment call. It's a bit of a facts and circumstances. You might be in a situation where there is absolutely nothing you can do about it. You don't know. It's out of your control. The grantee is doing it. It's not within your control. So I think that probably is something where it may be fine and there's just nothing you can do about it. But if there's some control that you're exercising, I think that could provide that could create more of a self-dealing concern. I think we're going to wrap up there, and I'll turn it back to Althea.
Great. Thank you, Andras, so much for that presentation and for taking so many questions. To everyone, if you still have any questions left over, you can send it to our Q&A service. If you do have Signature Plus, we actually will send it right back over to Andras, as Lauren said in the chat, because he is our attorney for our Signature Plus membership level. So if you have any questions about that, definitely reach out to us and we'll get you in touch with the right person. And that brings us to the end of the presentation today. Thank you so much for being here for all 3 of these sessions of this Legal Essentials virtual seminar. Bye. Thank you, Andras.
Great. Thank you. Thanks, everyone.